let's hear the matter and proceed. Thank you.
My lords and my lady doctor, if it pleases you in the matter, my name is Wamboi, Shadrach Wamboi. I speak with the blessings of my senior, Mr. Danstan Omari and Samson Nyaberi, on behalf of the 9th petitioner. My lord, at the very outset, permit me to submit that this court has a duty, either individually or as a collegial bench, to hear and determine the matters that are presented before court. Indeed, just like any other person, you have a duty to act in the defense of the Constitution. However, matters that relate to the calling to question of the conduct or the integrity of the bench or a judge are matters that are characterized in this country with a lot of rage, as we have even seen being demonstrated in this honorable court. In other occasions, applications for recusal, my lady and my lords, are said to be a dialogue of the deaf and a dance of the blind, to the extent that the petitioners or the applicants making an application such as the one that finds itself before you sometimes refrain from even saying the very grounds upon which they make the application, as you have seen before this court. And again, the bench on the other end, on many occasions, tends to draw conclusions of what they will think the applicant is saying about their conduct or their integrity. So for that reason, my lady and my lords, the court is then called upon to reflect as to its duty to do that which is just vis-a-vis the perception, either actual or apparent, that will flow or be submitted by applicants who call to question the conduct of the court. My lady and my lords, permit me to also make a contribution with regards to the decision that has been made in the Supreme Court case of Dari Limited. And there is something that is important that we must highlight. In this application, the Supreme Court was not called upon to adjudicate on an application for the recusal of the court. That was not the application that was lying before court. What is important that we must underscore in this case is that the court was invited to suspend or stay its proceedings in view of a complaint that had been made by the applicants before the Judicial Service Commission, so that the court ultimately ended up recusing itself, not that it had been invited to recuse itself, but because there had been a complaint that had been filed before the Judicial Service Commission. My lady and my lords, the reason why the 9th petitioner rises in support of the submissions made by counsels who have made the application is largely due to our duty as the officers of the court. And we have seen in the application in petition number E015 of 2024, annexure marked DMM2, which is a letter addressed to my colleague Mr. Swanya of Swanya and Company Advocates from the Judicial Service Commission, highlighting a complaint that has been made by the Deputy President of the Republic of Kenya, His Excellency Rigathi Gachagua, against this honorable bench. So, my lady and my lords, as I rest, the question that begs the answer is simple. If a complaint has already been lodged against the persons of this honorable court, how will a reasonable person, or will a reasonable person out there be confident that this court, in light of the complaint that has been lodged against you by one of the petitioners, arrive at a just finding in this case? My lady and my lords, that should mark the end of my submissions. I shall pave the floor for the remaining minutes to my seniors to also speak some wisdom to what is in issue. Thank you.
My lady and my lords, my name is Sam Nyaberi.